Property Disclosures, the Real Estate Professional's Guide to Reducing Risk. Page 18, Chapter 2. Benefits of disclosing other stigmas. Even if state law dictates that certain stigmas do not need to be disclosed, disclosure may still be in the best interest to avoid liability. For instance, buyers and lessees from certain cultures may wish to avoid properties where a death has occurred. In the late 1980s, an Asian couple purchased a home in California where the seller's son-in-law had hung himself in the basement. The neighbors disclosed this to the purchasers after they had moved in. The purchasers sued the seller and the listing agent for not disclosing this information. California has a stigmatized property law that states that the death did not need to be disclosed, and the defendants prevailed in the lawsuit. Disclosing this information on a voluntary basis, however, would have prevented the lawsuit because the couple would have purchased a different property. New York court reviews parties' duties to disclose information regarding haunted house. Stombovsky versus Ackley, 169 AD 2D 254 572, New York S. period 2D 672 1991. The New York Appellate Division addressed whether a seller and/or broker had a duty to disclose the purported presence of ghosts in property. The court found that neither party had a legal duty to disclose the ghosts, but granted the equitable remedy of rescission, holding that the seller, who promoted stories about the ghosts in local and national publications, could not deny their existence. The buyer had learned that the house was reputed to be possessed by poltergeists, and neither the seller nor broker had disclosed this information. The buyer sued for rescission and damages. During the previous decade, the paranormal activity had been featured once in Reader's Digest and in the local press. The New York Supreme Court dismissed the complaint and the buyer appealed. The New York Appellate Division granted rescission to the buyer on the basis that the seller deliberately fostered the public belief that her home was possessed. Even though the state recognizes caveat emptor, the court also noted that whereas here the seller does not only takes an unfair advantage of the buyer's ignorance, but has perpetuated a condition about which he is unlikely to inquire, enforcement of the contract is offensive to the court's sense of equity. Megan's Law. The federal Megan's Law, enacted in 1996, is named for 7-year-old Megan Conca of Hamilton County, New Jersey, who was sexually assaulted and murdered by a twice convicted sex offender living across the street. On July 21st, 1997, the Department of Justice published final guidelines for the states on implementing the new law, which makes the identification of convicted sex offenders mandatory to preserve the safety of citizens in any given community. While Megan's Law was written to mandate community notification, it also allows states flexibility in deciding an appropriate notification process. Some states require the police to alert the community when a convicted child sex offender has moved in. In Texas, a judge ordered lawn signs posted at offenders' homes. In page 19. In California, information is available only at police and sheriff stations, leaving neighbors of the offender unaware of past crimes. Other states post information on easily accessible websites. Several states, including Arizona, California, Idaho, Minnesota, Oklahoma, and Pennsylvania, include an exemption for real estate licensees with respect to disclosure requirements, unless a state law specifies that notification responsibilities lie solely with law enforcement entities. It might be implied they could be transferred to other entities or individuals, such as real estate agents. It is unclear what this may mean for real estate professionals who are required by professional licensing standards to disclose material facts. In New Mexico, the license law, rules, and regulations state that the location of sex offenders is not considered to be an adverse material fact. Real estate professionals should check their state laws and licensing standards for guidelines on disclosure of sex offenders. Case law. A New York appellate court has affirmed a lower court's ruling that in New York, sellers and their real estate broker/sales associates do not have a duty to disclose the presence of a convicted sex offender in the neighborhood to a buyer. Glazier versus Low Presti, 717 New York S2D 256278 AD 2D 198 and New York APP Division 2000. Neil and Carrie Glazier, buyers, learned after purchasing a home that a convicted sex offender lived across the street. The buyers brought a lawsuit against the seller, the broker, and the salespeople who represented the seller during the transaction. The buyer's lawsuit claimed that the seller, the broker, and the salespeople fraudulently concealed from the buyers the presence of the sex offender. The trial court ruled that the seller, the broker, and the salespeople had no duty to disclose the presence of the convicted sex offender to the buyers. The buyers appealed. The Supreme Court affirmed the decision, stating that no confidential relationship existed between the buyers and the others. The court also noted that the buyers had made no effort to discover the character of the surrounding neighborhood, which would have revealed that a convicted sex offender lived there because it had been reported in the local media. Constitutionality concerns. Opponents of Megan's Law argue that the law is unconstitutional and that child sex offenders are, in effect, being punished again and again by publicizing their names and whereabouts. Even if authorities have determined they are no longer dangerous, Maureen Konka, Megan's mother, believes, however, that pedophiles do not have the same rights as other felons. Pedophiles prey on children. They prey on the most vulnerable in our society. As long as they prey on our kids, we have every right to know who they are and where they are living. In a key first test of Megan's Law provisions, the U.S. Supreme Court ruled on March 5th, 2003, that sex offender registries are not unconstitutional extra